flag. And at their meetings, if anybody displays the flag, they discourage it.
Yes. What we know on the facts on that very argument, I just want to refer your Lordship to see.
They say that, and I'm just thinking if you didn't actually.
Yes, now I must deal with it now.
Just say that you wanted to use flag.
Yes, now I must deal with it now. Because what we know on the facts on that very point is that if your Lordship, we know the facts here that what triggered this application is the display at the so-called Black Monday. And the explanation for Black Monday was farm matters. And AfriForum admits that it organized that particular meeting. So what we know on the facts there is that the statement that was issued by AfriForum, Ernest Roots, at page 74 and 75 of the pleadings, 31 October 2017, and page 75, this is what he says. Now, you remember that the complaint was, at your meeting, AfriForum, there were displays of the old South African apartheid flag. Their response is this, page 75. Roots also confirmed that no flags were displayed at any of AfriForum's actions yesterday. In other words, the 30th of October 2017. Photos of flags doing the rounds on social media with the allegation that it was displayed yesterday has already been exposed as fake. So what they actually said, when we know factually that at that meeting there were displays of the apartheid flag, they did not at that meeting ask for the flag to be taken down. Instead, on the following day, they claimed that those people who were alleging that the displays of the flag at the Black Monday were spreading fake news. So I'm afraid, my Lord, their words do not match their actions. When the flag was displayed, they did not ask for it to be taken down. Instead, they denied that it had been displayed at all. And what is most striking is that in these papers, they do not deal with that striking contradiction. That you told us that you do not encourage anyone to display the flag, and that whenever you see it, you ask for it to be taken down. But on the 30th of October 2017, we know that it was displayed, and what Ernest Roots did was to deny that it was displayed at all. So we should not, I submit, accept the denial attitude taken by AfriForum, because they want to take one official position, but quite another unofficial position where the flag continues to be displayed in their events and in their name. And when they are taken to court on that very issue, they say, well, it's got nothing to do with us. It's people that we do not know. But television does not lie. The pictures do not lie. This was there for everybody to see. And the Nelson Mandela Foundation says it was there. They do not deny that it was there in the papers, although publicly that's what Ernest Roots said. And this is the same attitude, my Lord, interestingly, that is taken by FAK. They claim to be culturally enlightened. But the fact of the matter is that they never called AfriForum to task for displaying the apartheid flag. And they themselves say we have nothing to do with the flag. And so they want to create the impression falsely before this court that the displays of these flags have nothing to do with them. Whereas in reality, they've created the platform for the display of these flags. And in addition to having created the platform for the display of this flag, have defended the people who have displayed these flags on the basis that those of us who are asking for them to shove these things away are violating their freedom of expression. And so what actually is the truth here? The truth is that there is doublespeak on the part of AfriForum. On the one hand, they are telling the court we are part and parcel of a civilized society, we do not want to offend your feelings. But on the other hand, they are telling Mr. Hattam that next time you see this flag and you get offended, just sit down and reflect on how far your country has gone. And again, my Lord, in fact, there's a third point to be made about this. AfriForum exploits an issue that is of concern, which is the murders of people living in farms. This is a very manipulative and an exploitative issue of a matter that is of national concern, because one of their people who attended this, they were asked, why do you display this flag? And then they said, I displayed this flag because I felt safer in the old South Africa. Now again, AfriForum doesn't deal with that. I mean, the person who said so, everyone knows who they are, their name is here, the picture is there, and it is somebody who attended the meeting of AfriForum. And no one says at AfriForum, we went to ask this lady, why are you spoiling our events by displaying these flags, and why are you claiming that you felt safer in the old South Africa than you do in the new South Africa? So I'm afraid we should not tolerate the nonsensical proposition that AfriForum is opposed to the display of the flag. We should accept that on the objective facts, AfriForum is not opposed. In fact, they have created a platform for the continued display of the apartheid flag. There is obviously the other option that was available to AfriForum. They have claimed that they have come to court as a reluctant respondent. Why are they opposing the application?
Or are you asking them?
It's rhetorical. So, my lord, that is the short answer to the argument that AfriForum raises, that they don't like this flag, but at the same time they like it. And to conclude the historical journey that I was engaged in, it's obviously significant that when the bill was finally passed, it was passed together with a package of other statutes. We have summarized those in paragraph 34 of our heads of argument. Together with the Native Administration Act, which granted the Governor General the power to become the Supreme Chief of all natives and gave him vast powers to appoint and depose chiefs. And essentially, I mean, its primary purpose was to control the lives of native people. But it also paved the way for other statutes, the Native Representation Bill, the Native Trust and Land Bill, which took further the provisions of the Native Land Act, and of course the Urban Areas Amendment Bill. These were the so-called Herzog bills. And at the time of their introduction, there was a warning that was given by Smuts, Jan Smuts. And we have dealt with the warning that he gave in our heads of argument, which was rejected by Herzog. This is what Jan Smuts told them already in 1928. The more I see of politics, the more I love my studies. And the work in Parliament is doubly unpleasant just now. We are to have a joint sitting of both houses. Yes, I want to see where we refer to Smuts in our heads of argument first. My colleague says it's 33. Yes, paragraph 33. We are to have a joint sitting of both houses over the Calabar Bill, the Senate having once more rejected the bill. After the Asiatic Segregation Bill will come on as dangerous and unpleasant a measure as has ever been before our Parliament. Then he continues. Then Herzog will bring forward his native segregation bills. This will become a most unhappy country with policies such as this. This was Smuts telling them at the time they were introducing this bill, that if you look at what they are doing, they are consolidating Afrikaner aristocracy, Afrikaner hegemony, white power. And the consequences of this is that South Africa will become a most unhappy country with policies such as this. Nevertheless, they went ahead and they passed the bill. So, my lord, with that swift historical submission having been made, we can then go back to the provisions of Section 10 itself and see where we stand with this. So, What I am suggesting about this are 2 points. The one is on the meaning of the flag. We know factually what the meaning is. Secondly, insofar as FAK and AfriForum claim that there is no live dispute, their contention is in conflict with the pleaded facts. What does Section 10 of the Act then require? Your Lordship knows there are 3 primary disputes between us and AfriForum on Section 10. The one is whether or not words or only images are prohibited by the Act. The second is whether the words are so-called disjunctive or cumulative. And then the third is whether we've met the substantive test of the section. The first part of the debate, which is, does the section cover words or images, is dealt with respectfully better by Mr. Trengov and his team. We would not spend a lot of time on that issue. We will leave it to the Human Rights Commission to develop the argument. What we want to say is only one aspect around the question of the words versus symbol, is that we would submit that Your Lordship should read the reference to words in Section 10 in an expansive way, because that is the only way the full context of Section 10 can make sense. We say that for 3 reasons. Firstly, the Act itself says that it must be interpreted consistently with the Constitution. We say that if you uphold the contention submitted by AfriForum, the effect would be an outcome that is in conflict with the Constitution. In other words, it will enable people to superimpose a picture of a baboon on the body of a black man, and that will not constitute hate speech, because it is not words but a symbol. And yet everybody knows that references to baboon and monkey were references specifically reserved for African people. And so, in the light of the provisions of the Constitution, where the ultimate goal is the protection of dignity, we say the outcome that AfriForum contends for would be an outcome that perpetuates the violation of dignity, the distinction between words and symbols. So, Your Lordship should look at words in an expansive sense for that first reason. The second reason is the old statutory construction reason.
Words in an expansive form to reach what?
To include symbols and images and pictures. And so the example I make about a face of a baboon imposed on the body of a black man, that would be within the reach of Section 10. But if you adopted AfriForum's argument, that would be excluded by Section 10. And that would ultimately result in an unconstitutional outcome. The second reason is the old statutory construction reason. Statutes must be read to avoid absurdities. And for the reason I have articulated above, it would be an absurd outcome if all of the elements of Section 10 are fulfilled, but nevertheless it is found that particular conduct is not hate speech because not words are used, but symbols. The third reason is based on precedent. 2 cases, Leroux versus Gay. We've already referred to those cases in our heads of argument. The most important are paragraphs 39 and 86. And Your Lordship remembers the 39 and 86. Yes, I must just find my Leroux versus Day. If Your Lordship, do you have the judgment Leroux versus Day? Your Lordship goes, I don't know if Your Lordship has been given Leroux versus Day. Oh yes, I'm told that it's in the first bundle that Your Lordship had regard to, which is Pride. That's Pride's bundle, yes. That's the one that Your Lordship had regard to initially. We have referred to Leroux versus Day in paragraph 68 of our heads. 39. And this is So we've referred to this in paragraph 68 at page 24, and where we say, hence, in Leroux versus Day, where a manipulated photograph had no caption but a defamatory meaning, the Constitutional Court accepted that meaning is usually conveyed by words, but a picture may also convey a message, sometimes even stronger than words. So that, Your Lordship will find at paragraph 39 of Leroux versus Day. And if one looks at paragraph 86, this is what is stated in the majority judgment by Brandt A.J. Leroux versus Day, and he is talking about another element of defamation, which is publication. And publication means the communication or making known to at least one person other than the plaintiff. And then he says it may take many forms, full stop. Apart from the obvious forms of speech or print, the injurious information can also be published through photographs, sketches, cartoons, or caricatures. So, if Your Lordship found, as we contend, that you should take an expansive view of the use of the term words to include images and photographs, Your Lordship, paragraph 86, no, of Leroux versus Day. And if Your Lordship found it, it is, I'm told, page 13 of Pride's bundle. The key point to make is that the Constitutional Court has accepted, at least in two passages. The first one is 39, where they explicitly accept that meaning is usually conveyed by words, but a picture may also convey messages, sometimes even stronger than words. And then 86, they talk about publication that can take many forms: photographs, sketches, cartoons, or caricatures. And so it is for those three reasons: reasons of constitutional consistency, reasons of statutory construction to avoid absurdity, and the reasons drawn from the law of defamation that make it clear that, at least for purposes of the law of defamation, both meaning and publication can be gleaned in instruments other than pure words. So sketches, photographs, pictures, they can also contain words. And paragraph 39 is much more important because it says sometimes a picture can convey symbolism that is much stronger than the use of words. And here we have precisely that very point, because in that one image of the display of the apartheid flag is a consolidation of collective meanings. Of course, meanings of pride for one section of the population, but also meanings of hatefulness and meanings of deprivation for another section of the population. So, we would submit, therefore, that you should read words expansively. What that then leaves us with is two elements to the argument. The first element I should deal with now is the subsections of A, B, and C of the Act. The Lordship knows the provisions of the Act. It simply says, subject to the proviso in Section 12, no person may publish, propagate, advocate, or communicate words, and that's what we've been debating, based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention. I'll come back to the substantive meaning, which is communicate words based on one of the prohibited grounds against any person. But to just deal with A, B, and C, be hateful, be harmful, or propagate, or promote or propagate hatred. So what we know from those words is that A, B, and C are all separated by semicolons. the question that has arisen in the argument, and it is a serious debate I should accept, because another judgment of this court has read those words in a cumulative sense. In other words, as requiring them to be all of those elements of A, B, and C to be coexistent before a finding can be made of hate speech. That is a case called Khumalo, South African Human Rights Commission versus Khumalo, and it's a judgment by Justice Sutherland. We gave your lordship a note just addressing the Khumalo point, and we've quoted Khumalo at paragraph 4 of that note, specifically the portion that Justice Sutherland makes a finding on. What is crucial in paragraphs 84 and 85 of Justice Sutherland's finding is that he relies on what he understands to be the constitutional interpretation with reference to section 16 of the Constitution. What he says is that you have to read section 10 in a way that essentially repeats or regurgitates section 16 of the Constitution, section 16(2)(c) of the Constitution. So he regards, in fact, these are his terms, he regards section 16(2)(c) as what he calls the perimeter to section 10. So that means then 2 points need to be addressed. The one point is, are these cumulative or disjunctive? The second is, what is the extent to which section 16 is a perimeter to section 10 of the Equality Act? On that disjunctive and conjunctive reading, we deal with this from paragraphs 8, 9, 10, and 11 of our heads of the new note that we have handed up. So firstly, we refer to the judgment of Ngobo versus Salimba. It is a judgment of the Supreme Court of Appeal. Now, it sets out the general rule that where a statute uses or and on and end, or usually means it should be read disjunctively, and end usually means it should be read conjunctively. That debate is then taken up in another judgment called Stachy and another versus S. We deal with that in paragraph 10 of our heads of argument, and specifically we refer to the judgment of the Cape High Court on this point, where we say in Stachy and another versus S, the Supreme Court of Appeal rejected the argument that a semicolon on its own implies the word end. And so if we then go back to section 10, what we see is that it uses semicolons, but it does not say end. And on the finding of Stachy and another versus S, the use of semicolons does not require the reading, the conjunctive reading, end. And this is where we put the point. S versus Stachy and another dealt with the interpretation of, as paragraph 10 of our new note, dealt with the interpretation of section 158(3) of the Act, and its interpretation was subsequently accepted as correct in S versus Domingo. Both arguments overruled S versus F. When asked, counsel was unable to submit that the court below had erred. What S versus F had held was, if one had a list A, B, C, or D, it means A and B and C or D. That is linguistically and contextually unsustainable. So, as a matter of linguistics, the use of semicolons is a sufficient basis to find that it is not the intention of the legislature to include the conjunctive end. It is intended to be disjunctive. In other words, the phrase hurtful, harmful, or promote or propagate hatred are all intended to be used separately from one another and not conjunctively. So a claimant for hate speech does not have to prove the cumulative existence of hurtfulness, harmfulness, or the propagation of hatred. So it is enough that we've come to court to say a particular conduct is hateful, we do not have to subsequently prove that it also incites harm or it also promotes or propagates hatred. So that is on the linguistic and contextual interpretation. We've relied on Stachy, we've relied on Ngobo, and we've relied on Domingo. That takes us to the second argument made in the Khumalo case by Justice Sutherland. We want to make two arguments on the finding by Justice Sutherland. The first is that it's clear that the finding that we've referred to in paragraph 4 is obiter. Justice Sutherland was not deciding in that particular case whether or not all of these elements must coexist before a finding of hate speech can be made. He did so in passing, because what he found on the facts was that all three elements, hatefulness, harmfulness, and propagation of hatred, were present in that case. So, firstly we say those words and that finding was made in passing. But nevertheless, it was erroneous, even if it was not made in passing. And the reason it was erroneous is because Justice Sutherland failed to understand the import of the Islamic unity case, the judgment of Justice Langa in the Constitutional Court. Because the Islamic unity case makes it clear. Yes, at paragraph 15.
That's of the Islamic unity.
Yes, that's the Islamic unity case. And we've quoted there paragraphs 32, 35, and 43 at paragraph 15 of the note. So those extracts come from Islamic unity case. So the point I'm making here is that the second reason why your Lordship must reject as clearly erroneous the finding made by Justice Sutherland is that it misread Islamic unity case. In this respect, what Islamic unity found in paragraph 32 is where the state extends the scope of regulation beyond expression envisaged in section 16, it encroaches upon the terrain of protected expression and can do so only if such regulation meets the justification criteria in section 31(6) of the Constitution. And then it continues. But let me emphasize the one point here. Section 16 does not impose the so-called perimeter within which section 10 of the Equality Act must be read. What section 16 does is to regulate what forms of speech constitute, for purposes of section 16, what forms of speech are constitutionally protected and what forms of speech fall outside the preamble of constitutionally protected speech. What it doesn't do, it doesn't impose an obligation on the legislature that it may not regulate other forms of speech in ways that may constitute hate speech for civil purposes, or sometimes in ways that may constitute hate speech for criminal purposes. It simply defines the perimeters of speech. And Islamic unity makes the point clear that it is within the power of the legislature to decide on speech that is outside of section 16, how to regulate that speech. In this case, this is precisely what has happened in relation to the Petuda Act. The legislature has decided it will regulate this form of speech, and it will do so through the mechanism of what it calls hate speech. And that if you violate the statute, you will be visited upon with civil remedies. We know from the affidavit filed by the minister that the legislature is in the process of doing so in relation to criminal forms of speech. So section 16 should not be read as a perimeter. What it should simply be read to be is it defines what forms of speech are constitutionally protected and what forms of other speech do not fall within the protections of freedom of expression. And so, because we submit Justice Sutherland erroneously read the Islamic unity case, your Lordship should find that he was clearly wrong if you do not find that you are not bound in any event, because what he found was obiter. And so if we are right then that Section 10 constitutes a legitimate exercise of legislative power by Parliament in deciding for itself what it should do about speech that is outside the perimeters of Section 16.2. The only real question may be whether Section 10 is constitutional or not. But luckily, your Lordship does not have to decide that issue, because in this case, there is no one who challenges Section 10. So your Lordship must accept Section 10 as passed under the Equality Act, and the only debate that is confronting your Lordship is what does it mean. And so those are the two arguments. One is the scope of the term words. The second is the disjunctive versus cumulative question. What we are then left with is whether we have shown, as the section requires, that the words that were published were based on one or more of the prohibited grounds against any person and could reasonably be construed to demonstrate a clear intention to be hurtful, harmful, propagate, incite harm, propagate or incite hatred. And that's what I call the substantive elements to Section 10. We have already illustrated to your Lordship that the symbolism of the apartheid flag is a symbolism of racial domination. And so we would meet the requirement of prohibited grounds, because under Section 1 of the Act, one of the prohibited grounds is race. Could these words, if we are right that the flag incorporates words, could these words then be reasonably be construed to demonstrate a clear intention to be hurtful? We know from AfriForum versus Malema that the test to be used proceeds from the perception of the person against whom the words are directed. What Justice Lamont found in AfriForum versus Malema is that singing the song Dubulibun and deciding whether or not it's prohibited by Section 10 should be judged from the perspective of, quote-unquote, the victims of the speech. The same, I'm afraid, applies here. Whether or not the display of the apartheid flag demonstrates an intention to be hurtful or harmful or to propagate hatred must be judged from the perception or the perspective of the victims of racial domination. That means it must be judged from the perspective of the native races at the time, 1928. That is how they were described. Today they are called black. What does Mr. Hatang say about this? Mr. Hatang is quite clear from his affidavit about the impact of this flag. Firstly, he has spoken about himself. And we know that Mr. Ernest Roots has been very dismissive. And when there was a television debate, he told them that you should not turn South Africa into a communist police state. So we know from paragraph 13, and I have already referenced paragraph 13, page 12, about the impact of the speech on the recipients. Mr. Hatang says it made him remember two incidents in his upbringing. The one is being called a kafir, the other is being called a bobeyan. But we,
should Mr. Hatang be taken to be a representative of the recipients?
yes, it would be enough, my lord, assuming that the answer to that is that it would be enough if one person came without representing anyone and said that you've committed hate speech against me. If somebody said, Mr. Hatang, you are a kafir, that would be enough for Mr. Hatang to come to court on his own and say there was hate speech against me. He does not have to come to court as a representative of a wider class of the population. But in this instance, we also know that Mr. Hatang talks in general terms about the impact of the flag on people such as him, people in his position. But luckily in this case, we don't have that problem because we've got the Human Rights Commission that is also given, which is an organ of state and which acts in the public interest. We also have the Minister of Justice, an organ of state acting in the public interest. Both of them, their interpretation and meanings of the flag coincide because both of them speak of this flag as a symbol of apartheid racial domination. So, although it's correct that Mr. Hatang would have been entitled to come to court and say that it's offensive to me and I want a declaration to that effect, here, the two organs of state that have come to your lordship have told your lordship that even from where we stand, we regard this flag as particularly offensive on the grounds of race because it is a symbol of racial domination. That issue is dealt with at paragraphs 84, 85, 86 of our heads of argument. In 84, we've dealt with what Mr. Hatang says. In 85, we've dealt with what the Human Rights Commission says. 85.1, 85.2, and 85.3. And 86, we've dealt with what the Minister of Justice says. And the Minister of Justice says that the flag imputes to those hoisting it that they reminisce and long for the days when the old flag was the national flag of the country between 1928 and 1994. So, quite clearly, if one adjusts the display of the flag from the perspective of the victims, it's quite clear that its meaning is one of racial superiority, and worse than that is one of racial domination. AfriForum, interestingly, does not seriously engage with the impact of this flag. What it has said is that it acknowledges at page 79, was that it acknowledges that the flag has the capacity to cause offense and emotional distress. And yet the evidence is the flag caused offense, and it's not about emotional distress. It's not as if someone is just offended that they have been dumped by their girlfriend. It is simply an assault to human dignity that is represented by the flag, and that is what AfriForum does not seem to grasp. But
aren't they saying, in the words you're quoting, that it has that capacity?
Yes. But on the facts here, Mr. Hatang says, I saw the flag and this is what happened to me.
But the AfriForum says it has that capacity.
Yes, precisely.
It's not a denial.
Yes. Well, it's yes, I accept your Lordship's point. I misunderstood your Lordship. Yes, your Lordship is right. And then they say, but that form of capacity must be understood against other flags that have the same capacity. What are those other flags? The flags of the ANC, the flags of the Communist Party, the Union Jack, and then the Gay Pride Rainbow flag. I mean, well, this is absolutely staggering.
The first amicus in this paper.
Yes.
But do we go that far in order to interpret whether or not the complaint has been made?
Yes.
I suppose what AfriForum is doing here is to warn to say, if you go too wide, you will achieve unintended consequences.
Yes.
But I'm not sure you guys will guide me whether we go that far.
No, your Lordship is...
The display of this flag.
Yes, the parameters of this case are about the display of the apartheid flag. There is no case before your Lordship about the display of the ANC flag, or the display of the Communist Party flag, or the display of the Gay Pride flag. There's no debate about those flags in this particular case. There's only one flag, it's the apartheid flag. And one of the reasons why your Lordship does not have to go beyond the apartheid flag is that on the pleaded case, we know precisely what Malan wanted to achieve when he introduced this flag. And that is why one must be confined to the pleadings of the case. And all of these whatabouteries, which are really the essence of the argument by AfriForum, what about the ANC flag, what about the Gay Pride flag, what about this one, are completely irrelevant to the facts of this particular case. AfriForum must tell us why white people in white events must continue displaying the apartheid flag. Now, so if I am right then in the third proposition that I made to your Lordship, that I have shown that if you look at prohibited grounds against any person that could reasonably be construed, that must be viewed from the perspective of the victims of the speech. The only question really is then whether this is hurtful, harmful, or propagates hatred. We've shown that it is hurtful because not only does it have the capacity to offend or cause emotional distress, but what we argue is that it is degrading, it is dehumanizing, it is an assault on human dignity, because it is a symbol of a system that was rightly described in 1973 as a crime against humanity. That leaves only one issue, which is what remedy should your Lordship give if we are right? Oh well, yes, I did want to refer your Lordship to the cultural argument. There is an argument made about culture, that one of the reasons it is being displayed is culture. That cultural argument has been thoroughly answered by the Constitutional Court in City of Tshwane versus, interestingly, AfriForum, where they went to the Constitutional Court to ask for the retention of the apartheid names on the streets of Pretoria or the streets of Tshwane. Both the majority and the minority specifically said the culture that preserves domination is inconsistent with the Constitution. And it is true that AfriForum is entitled to promote its culture. What it is not entitled to do is to promote racism. And by retaining apartheid street names, it was promoting racism. Precisely by arguing for the continued display of the apartheid flag, it's promoting racism.
The reference to City of Tshwane, is it anywhere in the text?
It is paragraph 47. It is in paragraph 47 at page 18. This is now the judgment of Froneman J. and Cameron J. They wrote for the minority. They say, paragraph 47, to deny these realities or avert one's eyes to them lays one open to a charge that what one seeks to protect is not culture, but a heritage rooted in racism. The Constitution protects culture, yes, but not racism. It's clear that if you want to continue displaying the flag on the so-called cultural premise, what you want is the preservation of a heritage rooted in racial domination. That's not protected by the Constitution because it perpetuates racism. The same point is made by Justice Jafta at paragraph 48, where he deals with the cultural argument. There can be no justification for recognition of cultural traditions or interests based on a sense of belonging to a place where one lives if those interests are rooted in the shameful and racist past. And then if one continues to the following page at paragraph 19, any claim to the enjoyment of culture may not include an entitlement to racist and oppressive cultural traditions of the colonial and apartheid era. Recognition of racist traditions is inconsistent with our constitutional order, which seeks to establish a society in which all human beings will be accorded equal dignity and respect, regardless of their membership of particular groups. And Justice Mogoeng, who wrote for the majority in paragraph 49, makes the point clear. White South Africans must enjoy a sense of belonging, but unlike before, that cannot and should not never again be allowed to override other people's interests. South Africa no longer belongs to white people only. It belongs to all of us who live in it, united in our diversity. Any indirect or even inadvertent display of an attitude of racial intolerance, racial marginalization, and insensitivity by white or black people must be resoundingly rejected by all South Africans in line with the preamble and our values if our constitutional aspirations are to be realized. So all of the judgments, the minority and the majority, were quite clear on this, that you are entitled to culture. What you are not entitled to is racism. The flag is racism, period. What remedy should your lordship give? We've dealt with this in page 38 and 39 of our heads of argument. The lordship will remember that there are all of these arguments raised that you can't give a remedy because it will not be capable of enforcement. It will just drive those people who want to display the flag underground. It will be impossible to police, etc., etc.
How much longer are you still going to do?
I am no more than 5 minutes, my lord. Is this? Apparently it's 11:15, so I can take the adjournment and then come back and finish in less than 5 minutes. I'm really at the end.
What do you want to do?
Perhaps I should take the adjournment in case my juniors, who know better than I do about this case, have something to say to me.
What adjournment?
All right.
The whole point about enforceability is dealt with in paragraph 111 of our heads of argument, where we quote finding made by Justice Lamont in AfriForum versus Malema. And the Lordship will remember there in a case about the singing of the song Tubulibun, one of the arguments made was how on earth are you going to enforce or police the singing of the song? And this is how Justice Lamont dealt with it. It was submitted that the law might be unable to enforce its order in the form of an interdict, as people are passionate about the right to sing the song and will ignore the order. They will sing the song in private or in circumstances where it is difficult or impossible to prevent. And then he says the answer is that such people must pursue new ideals and find a new morality. They must develop new customs and rejoice in developing society by giving up old practices which are hurtful to members who live in that society with them. Of course, the shoe was on the other foot there. And then he continues, persons who are not parties to the proceedings must be dealt with by way of structuring the order so that society knows what conduct is acceptable. Persons who are aware of the line which has been drawn by the court are, as a matter of both law and Ubuntu, obliged to obey it. There may be no immediate criminal sanction. Their breach of the standard set by this court will, however, surely result in the appropriate proceedings under the Equality Act being taken against them. Non-participants are bound by orders setting such standards. And so, if your Lordship granted a declaratory order as we seek, it does not matter that there are other people in private that may continue displaying the flag. What is crucial is that your Lordship would have set a constitutionally appropriate standard. And if people want to continue acting in breach of the court order, those people will be dealt with in due course. But they do not have to prohibit or prevent or somehow stultify the powers of this court under Section 21 of the Act. There is no debate on costs. This is not a case in any event where costs are appropriate. Those are the submissions. Thank you.
Please, my Lord. I propose to address 3 topics. I will start with a brief, but I submit important submission about the symbolism and meaning of public displays, gratuitous public displays of the old flag. My learned friend, Mr. Kadobi, has already dealt with the issue in the sense, and he's emphasized the history of the old flag. I will submit that he's been unduly gentle and generous in his characterization of today's symbolism of public displays of the old flag. It is a lot worse than he suggested. I will then address two main topics. The one is the proper interpretation of Section 10, which on its face speaks about the publication of words. We will submit that that expression must not be literally interpreted. It must be understood to relate to the publication of all ideas, whether by words, conduct, or symbols. I'll address a third topic, which is in the alternative to the second. And that is to say that if we are mistaken, if the section is to be interpreted literally to be confined to the publication of words, then it is unconstitutional. And it should be declared unconstitutional, and the constitutional defect should be remedied. And if I may explain in advance, my Lord, I will be running the second and third arguments or topics together for this reason. And that is that the main reason why we submit that the section ought not to be literally interpreted is precisely because its literal interpretation will render it unconstitutional. So I will deal with the constitutionality of the section, both in its literal sense and in its broader sense. Firstly, as part of my case on interpretation, but also as part and parcel of the alternative case, which says, but if you are not with us on the interpretation, then the section is unconstitutional. May I start then with the symbolism of the gratuitous public display of the old flag. And let me make it immediately clear that what we're talking about is not a ban of the flag altogether. What we're talking about does not in any way impinge upon the rights of racists to have private functions at which they wave their flag. The order also does not preclude the exhibition of the flag in appropriate places. In the Apartheid Museum might be one. And there might be other occasions where it would be appropriate to display the flag. What we're talking about is the gratuitous public display of the old flag. That is, people who go around in public waving the old flag. And the first inquiry must be, what does it mean when they do so? And why do we suggest that that is hate speech? Well, my learned friend has demonstrated how the flag was in its history a white flag, a racist flag. But that was not where it ended. It ended its life as the symbol of the apartheid state. And that is what it is today, is the symbol of the apartheid state. And if people go around in public waving the symbol of the apartheid state, what is it that they say? We submit that what they clearly say and what they clearly mean to convey to everybody around them is that they express nostalgia for apartheid South Africa. They yearn for apartheid South Africa. They celebrate apartheid South Africa. And what is it that they are nostalgic for, that they yearn and what they celebrate? It is a state of institutionalized racism, a state which was founded on the racist principle. And those principles are very easy to define. It is a state in which the supremacy of white people was institutionally entrenched and celebrated. And the other side of the same coin was that it was a state in which the inferiority of black people was institutionalized and emphatically implemented. So what do these people say who go around in public flying a flag to express their yearning for apartheid South Africa? What they say is that we yearn for the good old days when we lived in a state that entrenched and celebrated white superiority over black people. A state that humiliated black people in every aspect of life. That is the state we yearn for. A state in which white people were celebrated, black people were humiliated. And remember too that when these people wave their flag in democratic South Africa, then what they do is not only to wave the flag of apartheid South Africa, they also choose not to wave the flag of democratic South Africa. Our Constitution incorporates its own flag, the flag that is symbolic of democratic South Africa, of non-racist South Africa, of diverse South Africa. And what these people who wave the old flag, what they do is not only to wave the apartheid flag, but they also choose not to wave the flag of democratic South Africa. So it reinforces the racist message. We yearn for the old racist South Africa. We don't identify with a new democratic, non-racist South Africa. That is the message that they send. And secondly, they do it in public. What that means is that they do it in full view of the black people who were humiliated and degraded by the apartheid state. So they say to all around them, including all their black compatriots around them, I yearn for the state in which you were oppressed and you were humiliated and my superiority was recognized and entrenched. It is a profoundly humiliating and insulting statement to make to their fellow South Africans who were the victims of the racism in apartheid. To say to them, I celebrate apartheid, I yearn for apartheid, I am nostalgic for apartheid when I was supreme and you were kept in your place. It is a profoundly humiliating, degrading message they send to all black people. And it's also confined to gratuitous displays. That means displays without good reason. So we don't need to speculate about all those occasions where there might be some justification for waving the flag. We're talking about gratuitous and insulting waving of the flag. So when one gets to section 10, we would submit with respect that this debate about conjunctive and disjunctive, whilst an interesting debate, is not a necessary one for purposes of this case, because the message publicly conveyed by those who wave the apartheid flag is a hurtful message. It is also a harmful message. It incites harm on the racist grounds, and it propagates hatred because it propagates the superiority of the white race over the black. So even if you were to adopt a conjunctive interpretation of the section, we would submit that the display of the flag is manifestly in contravention of the section in that it contravenes each one of the three components of it. So we submit with respect that there is a clear contravention. But may I now turn to my second issue, and that is the proper interpretation of the section and the meaning of the word words, together with the unconstitutionality of the literal interpretation of that section. And Lord, may I for that purpose hand up a bundle of our authorities. You will see the file also includes the Johannesburg Pride authorities in the second section, but you might already have a copy. And I have also, on the top of the file, included extracts from the Constitution and the Equality Act, simply because those are the extracts on which I would like to place emphasis in my submissions that follow. So if I may start, my Lord, with the extract from the Constitution and emphasize the following provisions. The Constitution analysis must always start with Section 1 because it articulates the founding values of the Constitution, and we emphasize, for purposes of this debate, the founding values in 1A and B, that is human dignity, the achievement of equality, and the advancement of human rights and freedoms, and B, non-racialism and non-sexism. And then if one goes to Section 5, it is the section that prescribes our national flag. The national flag of the Republic is black, gold, green, white, red, and blue, as described in Schedule 1. And it's important because, for the earlier point that I made, we have a democratic South Africa flag. We have a flag that is symbolic of the democratic, non-racial South Africa. People who wave the apartheid flag choose not to wave the democratic South Africa flag. Then if one goes on to Section 7.2, the state must respect, protect, promote and fulfill the rights in the Bill of Rights. I will get to the rights which the state is obliged to respect, protect, promote and fulfill, but they include equality and human dignity. Then goes to section 9, that's the equality section. It says that everyone is equal before the law. It prohibits discrimination on various grounds, including race. And then sub 4 says the following: no person may unfairly discriminate directly or indirectly against anyone on one or more of the grounds in terms of subsection 3. And then the important section: national legislation must be enacted to prevent or prohibit unfair discrimination. That is the origin and the purpose of the Equality Act. And if it doesn't serve that purpose, then it would be unconstitutional. Next important provision is section 10. Everyone has inherent dignity and the right to have their dignity respected and protected. Section 16 is the right that entrenches freedom of expression. And may I just emphasize the heading to the section. It speaks of freedom of expression. That means the expression of ideas by any means. It is not freedom to publish words. It is freedom of expression. And then there is, after conferring in section 16.1, everyone has the right to freedom of expression. Again, that word, the wide word, that means the expression of ideas by any means. And then in subsection 2, as my learned friend Mr. Nkadobia said, that excludes certain kinds of speech from protection. And the sub C is the important one. It excludes advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. I emphasize again that it is any advocacy, not advocacy by words, but any advocacy. And then lastly, on the Constitution, there is the well-known section 39.2 that says, when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, objects of the Bill of Rights. So much for the Constitution. The part I emphasize is that there's a constitutional duty on the state to prohibit race discrimination and to protect dignity. And that when it speaks of freedom of expression, it uses the wide phrase freedom of expression and not freedom to publish words. If I may then turn to the Equality Act. Firstly, in the long title, that is also the second document in that file, my lord. In the long title of the Act, it says its purpose is to give effect to Section 9. That's the prohibition of discrimination. Read with item 23.1 of Schedule 6 to the Constitution. That is a provision which speaks to the legislation that has to be enacted under the Bill of Rights. So its purpose is to give effect to Section 9. That's that provision of Section 9 that says national legislation must be enacted to prohibit discrimination on any ground. So it's the very purpose of this Act is to give effect to the prohibition of discrimination. And it goes on to say to prohibit unfair discrimination and harassment, to promote equality and eliminate unfair discrimination, and to prohibit hate speech. I emphasize hate speech, not hate words, hate speech. And we know that across the world, in South Africa and all over the world, freedom of speech and hate speech is always meant not to be confined to the freedom to speak language or words. It's a freedom of expression by any means. So its purpose is to prohibit hate speech. That's any expression of hatefulness. And then there's a preamble I don't need to take you through all of it, but if I can jump to the 5th paragraph, it says that Section 9 of the Constitution provides for the enactment of national legislation to prevent or prohibit unfair discrimination and to promote the achievement of equality. Again, making clear that its purpose is to give effect to the prohibition of discrimination. And then Section 2, the objects of the Act. The objects include the following. A, to enact legislation required by Section 9. That's again the prohibition of discrimination. And then if I go to B, to give effect to the letter and spirit of the Constitution. In particular, sub 4, the prevention of unfair discrimination and protection of human dignity as contemplated in Sections 9 and 10 of the Constitution. And sub 5, important, the prohibition of advocacy of hatred based on race, ethnicity, gender, etc., that constitutes incitement or cause harm as contemplated in Section 16.2. But it's again the prohibition of the advocacy by any means, not only by words, any advocacy. Sub C, to provide for measures to facilitate the eradication of unfair discrimination, hate speech. That's to eradicate all hate speech. F, to provide remedies for victims of unfair discrimination and hate speech. Again, not hate words, hate speech. And then we come to Section 3, the interpretation of the Act. Any person applying the Act must interpret its provisions to A, to give effect to A, the Constitution, which speaks for itself, but then B, the preamble, the objects, and the guiding principles of this Act. So these provisions through which I have trawled, that make it clear that the purpose of the Act is to give effect to Section 9, to prohibit all hate speech. That is object must be given effect to in the proper interpretation of the Act. And then and then in Section 3.2 also says matters that are really trite, but said here in particular, any person interpreting this Act may be mindful of B, international law, and C, comparable foreign law. And then one gets to the prohibition of hate speech itself. Firstly, the heading of Chapter 2 says prevention, prohibition, and elimination of unfair discrimination, hate speech, and harassment. It's again hate speech, not hate words.
Where are we?
Sorry, it's the heading of Chapter 2.
Yes.
It says, it again speaks about the prevention, prohibition, and elimination of hate speech. And then Section 10. Now we're getting to the crucial one. Subject to the proviso in Section 12, and I'm going to come back to that provision. No person may publish, propagate, advocate, or communicate words based on one or more of the prohibited grounds. That is the prohibition, and that's the phrase that we need to interpret. Now, we submit that when it speaks there of words, it means speech in the broad sense, or even more accurately, expression. Or if you want to accommodate the actual language in the section, we would suggest that words there means any ideas. That is what it means. And look at not only do we have the Constitution that says you must prohibit all hate speech, we have the Act itself which says my purpose is to prohibit all hate speech. But then look at the verbs used in that section, in 10.1. Two of them are quite inappropriate if by words one literally means words and not ideas. Because it says no one may publish. Well, publish words, that makes sense. But no one may propagate words. That's a nonsensical statement if words literally means pieces of language. Anybody who uses language can't ever be said to propagate words. What it obviously has in mind is propagate ideas. not propagate words. And it goes on to say, the next verb is advocate. Nobody may advocate. The same problem arises. How do you advocate words? You can't advocate words. You can advocate ideas. And that is what we submit. Those verbs make it clear that that is what they intend to refer to. They intend to prohibit any expression, any propagation, or any advocating of any ideas, not only words, which are hurtful, harmful, or promotes hatred. Can I come back to, can I come back to the opening words of 10.1? It says it is subject to the proviso in section 12. When one then goes to section 12, to the proviso in section 12, you'll see in section 12 there is also a prohibition of expression of unfair discrimination, but that's not the part incorporated in section 10. What is incorporated in section 10 is the proviso, and it says, provided that bona fide engagement in artistic creativity, academic and scientific inquiry, fair and accurate reporting in the public interest, or publication of any information, advertisement, or notice in accordance with section 16 of the Constitution is not precluded. So the important thing is that what it excludes from the prohibition is any artistic creativity, recognizing that ideas can be propagated or conveyed not only by words but also by artistic creativity, and it then protects or excludes artistic works from its hate speech prohibition. And lastly, can I go back then to section 10, and this time section 10.2, it also provides for an exception to 10.1. It says, without prejudice to any remedies of a civil nature under this Act, the Court may, in accordance with section 21.2m, and where appropriate, refer any case dealing with the, and here come the same words, the publication, advocacy, propagation, or communication of hate speech. So, if there would be a complete disjunct between 1 and 2, if 1 was confined to words, for 2 then to say, but any case about hate speech may be referred to a special mechanism. It is again an indication that when it speaks of words in sub 1, then it means the publication, propagation, advocating, or communication of ideas. And it is not so outlandish to give that word the meaning for which we contend. We already have an international acceptance that when one speaks of, for instance, freedom of speech, then that embraces a freedom which is not confined to the expressions conveyed by language. Freedom of speech extends to a freedom to convey ideas by any means, and I'll get to the international jurisprudence shortly. So we already have, when we speak of freedom of speech, an extended meaning of speech, which is not confined to language, but goes to any expression by any means. When we speak of hate speech, when the Act speaks of hate speech, the ordinary meaning is not hatefulness conveyed by language. The ordinary meaning is hatefulness conveyed by any means. Our learned friends have that excellent example of someone who sticks a baboon's head on a black man's body. Can it be suggested that that would not fall foul of the prohibition of hate speech? And we know that in our society there are any manner of insults that can be conveyed by pictures or hand gestures or by conduct. So that we would submit with respect that the section ought to be interpreted to prohibit any hateful expression of ideas, and not merely if it is done by words. As for the broader meaning of hate speech, we refer both to international law and to comparable foreign law in our heads of argument. I don't know whether you have a copy of our heads of argument at hand, my Lord. If I may go to our heads of argument at page 18. I need not take you through it because the jurisprudence, it's page 18, paragraph 45 and further. Firstly, under international law, under treaties binding on South Africa, South Africa is obliged to prohibit any advocacy of national, racial or religious hatred. In other words, our international law obligation is to prohibit the expression of racist ideas not only by words but by any means, so that the narrow interpretation of the section would also fall foul of South Africa's obligations at international law, and therefore also fall foul of the provision of the Equality Act, which says international law must be taken into account in interpreting the Act. And then there is comparative law in our heads, page 20, where we refer to the cases in the US, which have also made it clear that under their protection of the freedom of speech, the protection is not confined to the expression of ideas by words. The expression extends to the expression of ideas by any means. And interestingly, one of the cases in which that principle was acknowledged is the case we mentioned in our paragraph 54 of Texas and Johnson, where the court held that the public burning of the national flag constituted conduct which constitutes speech in the sense that it's an expression of an idea, albeit not by words. Well, if the burning of a flag can be speech, then so can the waving of a flag be speech. And so, my Lord, we submit in conclusion on my middle topic that there is overwhelming reason to interpret the Act, Section 10, its use of the word words, not in a literal sense, but as meaning any ideas. That is the interpretation that we would submit is consonant with the Constitution and consonant with the purpose and context in which the word is used in the Act. But if we're wrong, if your Lordship were to hold that the word bears its literal meaning as AfriForum contends, then we submit for exactly the same reasons that it is manifestly unconstitutional to confine the prohibition to harmful and hurtful and hateful statements by words but not by conduct, to prohibit statements that are well known comparing black people to animals by words, but not if it is done by my learned friend's picture. That is an absurdity which is not only absurd, but we submit manifestly unconstitutional because it does not give effect to Section 9 of the Constitution to prohibit all race discrimination, and Section 10 of the Constitution, and that is to protect the dignity of all people. And in that event, my Lord, we would ask that the court hold as the terms that we set out in at the end of our heads of argument in paragraph 74, only if your lordship were to uphold our interpretation of the section, then we actually don't require any relief. All you would then do would be to dismiss AfriForum's defence that the Act does not apply to them because it's confined to words. But we will then not ask for any interpretation, any specific order. But if your lordship were to uphold their interpretation, then we ask for the order that we set out in our heads of argument. The effect of it would be to declare the section unconstitutional, to give Parliament a year to fix it up, and in the meantime to direct that the section must be read to apply to words, to the expression, the publication of any words or ideas, so that it would embrace the ambit of the prohibition of the Constitution. At the end of the day, my Lord, we submit your lordship would be well guided by the Constitution, Section 39(2) of the Constitution, to prefer the meaning which is compatible with the Constitution. So we must not be understood in the first place to be advocating an order for the declaration of invalidity. That is only in the alternative, but we do submit the primary solution to this case is to adopt a meaning of Section 10, which is compatible with the Constitution. Thank you, my Lord.
Well, before you take a seat, the prohibition in Section 10(1) restricted to words. And words meaning a collection of letters. Where does sign language from?
No, it wouldn't be covered at all. Nor would Morse code be.
It's actually a question I want to ask to Mr. I don't know. It might well be that it's the argument.
Yeah.
The legislator had a choice. He chose to restrict to words. And if he chooses to, he will then come back and say sign language meaning the same words.
That is indeed so, my Lord, but I submit with the greatest of respect that my learned friend's example is the killer point. We know that it's a contravention of the section to call black people baboons. Does it then mean that one may publish pictures of black people with baboon faces? The law can surely not be as foolish and as absurd as that. And the way to avoid that absurdity is to recognize the word speech and the word words sometimes have a broader meaning in the context in which they are used. Thank you, Madam.
You don't want to say anything about cost, Mr. The attorney gave me a bye-bye before he says I say something about it.
Yeah, you've heard me complain that he's too generous to the other side. But can I take instructions on the issue? Do you want?
May it please the court. My Lord, your Lordship.
Good man, you are with amicus.
My Lord, I'm for the first amicus, Johannesburg Pride.
Yes,
Your Lordship will know that my client and the Minister of Justice both broadly support the relief sought by the applicants. And so, subject to your Lordship's direction, the parties have agreed that Ms. Kazi and I will make submissions before AfriForum and FNK Nuclears.
And the parties agree that?
Yes, my Lord.
I'll go on with the parties.
Thank you, my Lord. My Lord, my client's role in these proceedings is limited, and I'll confine my submissions accordingly. Johannesburg Pride was admitted as an amicus to put up evidence and to address argument on two topics before this court. The first relates to the impact of apartheid on members of the LGBTI community and on how the hoisting of the flag affects them. second topic centres around the meaning of symbols and the implications of ascertaining their meaning for AfriForum's slippery slope argument. And those are the only two topics that I propose to address, and I'll do so briefly. Turning then to the first topic. Johannesburg Pride's first submission is a reminder to the court that the apartheid regime centrally targeted and repressed black people, but that it also extended its discrimination and legalised oppression to members of the LGBTI community. A raft of laws, some of which are summarised in paragraph 21 of Ms. Nathan's affidavit at page 146 of the record, criminalised gay sex, as well as any non-heteronormative expression of gender identity. Members of the LGBTI community were at risk of prosecution and of persecution at the hands of the state, and their total exclusion from the ordinary mores of society has been repeatedly noted by the Constitutional Court. I may quote briefly from the Second National Coalition case. The full citation is at footnote 60 on page 19 of Pride's Heads. Constitutional Court has held that the sting of past and continuing discrimination against both gays and lesbians is the clear message that it conveys, namely that they, whether viewed as individuals or in their same-sex relationships, do not have the inherent dignity and are not worthy of the human respect possessed by and accorded to heterosexuals and their relationships. This discrimination occurs at a deeply intimate level of human existence and relationality. It denies to gays and lesbians that which is foundational to our Constitution and the concepts of equality and dignity, which at this point are closely intertwined, namely that all persons have the same inherent worth and dignity as human beings, whatever their differences may be. And the Constitutional Court continues, the denial of equal dignity and worth all too quickly and insidiously degenerates into a denial of humanity and leads to inhuman treatment by the rest of society in many other ways. This is deeply demeaning and frequently has the cruel effect of undermining the confidence and sense of self-worth and self-respect of gays and lesbians. So, my Lord, our point is merely this. I'm in National Coalition. I think it is paragraph 60, but I'm afraid I haven't made.
Paragraph 60 is footnote 60 of your text, but the portion you provide.
My Lord, I do apologise. I haven't made a note, but I will find it for your Lordship shortly. My Lord, the point for present purposes is only this, that the courts have repeatedly recognised the harm and the systemic oppression that members of the LGBTI community suffered under the apartheid regime, and that harm and oppression was systematically enacted through a series of legislation that rendered gay people second-class citizens under the apartheid state. The implication of that, my Lord, for present purposes, is that if the old flag is objectively a symbol of the apartheid state and of the oppression that it wrought, and we submit that it is, then it is a symbol both of the oppression of black people and of members of the LGBTI community. It is, as my learned friend says, an assault on the human dignity of both. It displays and celebrates not only institutionalized racism, but also institutionalized homophobia and the privileging of heteronormative values at the expense of members of the LGBTI community. To the extent that evidence is relevant on this, Ms. Nathan testifies in paragraph 29 of her affidavit, your Lordship will find it at page 147, that for members, 147.1 of the papers, that for members of the LGBTI community, the old flag is a symbol of autocracy, oppression, and denial of human rights, injustice, inequality, and hate. And inasmuch as hoisting the old flag or displaying it in public constitutes hate speech or harassment against black people, we submit that it also constitutes hate speech and harassment against members of the LGBTI community. It is, as Mr. Trengove submits, a profoundly humiliating and degrading message conveyed to each of them. My Lord, that then takes me to the second topic, which relates to the meaning of symbols and how those are properly ascertained by courts. And my Lord, this submission assumes importance in light of two arguments advanced by AfriForum. The first is that AfriForum suggests that, and this argument is made in paragraph 85 of their heads of argument, AfriForum suggests that symbols are innately harder to interpret and to assign meaning to than words, and it proffers this as a reason why it would be rational for the legislature to prohibit expression by words but not similarly prohibit expression by conduct. So we propose to address that argument. And secondly, AfriForum advances a slippery slope argument, suggesting that if the old flag were found to be hate speech, it would pave the way for a finding that other symbols should similarly be prohibited because certain people in certain contexts may similarly find them offensive. That argument appears at page 90 to 94 of their papers, paragraphs 41 to 50, and is repeated at page 40 of the heads of argument in paragraphs 39 to 40. My Lord, both of those arguments are premised on the supposition that symbols are not capable of an objective, definite meaning, that they are somehow, unlike words, inherently capable of being nailed down and understood objectively. And our first submission in this regard is that AfriForum's submission is simply wrong. Courts are equally capable, we submit, of interpreting words on the one hand and symbols on the other, and have done so routinely in the context of defamation proceedings. I don't propose to take the court through the cases that are summarised at paragraph 7 to 14 of our heads. So it's paragraph 7 to 14 of the heads set out the general principles dealing with ascertaining the meaning of images. Those cases culminate in the Constitutional Court's test set out in LaRue versus Day, which says that a court must ask in establishing the meaning of an image is what meaning the reasonable viewer would attribute to it. And then the second step of the test is to say, what is the impact of that meaning likely to have on the public or the reasonable viewer of that symbol? And so the test is clear. It's an entirely objective test. It takes into account the context, it takes into account public opinion, but what it doesn't take into account, my Lord, is the subjective intention of the person who makes the statement or who publishes the image. They are, as my learned friend for the Nelson Mandela Foundation submits, the meaning must be ascertained from the point of view of the person to whom publication is made. So, my Lord, AfriForum's suggestion with respect that a court cannot determine an objective meaning, or that there is some kind of inherent uncertainty around the meaning of an image is with respect incorrect, and it flies in the face of well-established jurisprudence of the court. Our second submission, my Lord, is that symbols, as a category of images, are particularly amenable to objective interpretation by a court, and that is because symbols are intended, they're developed and used as a signifier of a group an idea, or a representation. Their very purpose is to act as a shorthand for a particular idea. And so one would think that it is easier, not more difficult, for a court to ascertain what the underlying idea or thing which the symbol is intended to signify is. And my Lord, relatedly, flags are quintessential symbols. They are developed and they are hoisted as symbols of a particular country, of political parties, of movements, and that is objectively the meaning that attaches to them. There can, with respect, be no serious submission that the meaning of flags as symbols is imprecise, or that courts cannot objectively determine what they mean. My Lord, our third submission is that the objective meaning that a symbol bears is dependent on its currency and its implications in a particular society. Simply put, my Lord, context is important. It's a principle that our courts have recognized in a variety of places, but we submit that it is particularly important in the context of this case, because we submit that symbolic representations of a past order have particular potency in societies that are recovering from an abusive regime. So put differently, societies that have suffered from abusive human rights regimes and are transitioning out into a more unified society may take a particularly strong view in context of the symbols that have represented the old regime than they would be in other circumstances. It's why, my Lord, for example, a symbol like the hammer and sickle may be considered benign in the United Kingdom. It may be considered clearly political, neutral in the UK, benign in South Africa, where it is a symbol of a political movement that was associated with with relieving South Africa from apartheid and from oppression, but why it is nevertheless a hate symbol in societies that have suffered under a totalitarian communist regime. And my Lord, we've dealt at length in our heads of argument with the banning in transitional societies, or the limited prohibition in transitional societies of symbols that represent previous regimes, the hammer and sickle, the yellow star, the Nazi flag, swastikas and the like. We submit, my Lord, that the Court is enjoined in considering the importance of the old flag to take the context of South Africa and its past of human rights abuses into account. And my Lord, that takes me then to our final submission, which is the response to AfriForum's slippery slope argument. My Lord, we agree and endorse AfriForum's submission that courts, in recognizing that certain symbols may constitute hate speech, must be assiduous not to chill the use of legitimate symbols, which may nevertheless be controversial or offensive. But, my Lord, contrary to AfriForum, we say that courts can and routinely can draw those lines easily. And to that end, we have put up the case law of Hungary, Poland, and Moldova in our heads of argument. It's at page 13, paragraph 17. And we say it is significant because each of those courts has grappled with the boundaries of the permissibility of limiting the use of symbols. And although there are nuances and differences in each of the judgment, the line that they ultimately draw, my Lord, is this. They say that symbols that are unequivocally a signifier of a hateful regime can constitutionally be treated as hate speech, and their use can be constitutionally limited. So at the one end of the spectrum, you have symbols whose purpose and meaning is clear, and on the other end of the spectrum, they say that there are symbols that have multiple meanings, either because they are used for different things in different circumstances. The yellow star is an example of this, or because they are the signifier of a group or party whose ideology changes over time. And in those cases, they find that symbols that are on that more ambiguous side of the spectrum may not be amenable to a prohibition in all circumstances and will need to be more contextually considered. But my point, my Lord, is that the task before a court is to determine where the symbol that it is faced with lies on that spectrum. And we submit here the old flag is clearly on the prohibition side of the spectrum. We say it was created as a symbol of pre-constitutional South Africa. It was exclusively used for that purpose. Its use came to an end at the end of the apartheid era, meaning that there is no opportunity for its meaning to change and develop and fluctuate over time. And it has become objectively and unequivocally a signifier of that regime and cannot be disassociated from it. So we submit that the old flag can only plausibly and reasonably understood as a representation of the apartheid regime and the hate and the intolerance that it engendered, and it is that on that basis that it is unequivocally hate speech under Section 10 of the Act. Submit, my Lord, that the meaning of the rainbow flag, and as your Lordship has noticed, this is where my client's interests lie, the meaning of the rainbow flag is similarly unequivocal. It, like the old flag, was developed for a particular purpose. It has become and has consistently been used to identify a particular group and a set of values. But, my Lord, it is at the other end of the spectrum of values. It has consistently been used as a symbol of gay pride, of tolerance, of equality, and we submit that there is no foreseeable prospect that the meaning of that symbol will become so elided that it could somehow be banned either by the court or by the legislatures. My Lord, finally, to deal with the other examples raised by AfriForum, the flags of the ANC in the various countries that it cites fall somewhere in the middle of the spectrum. What those symbols signify is clear. They are an identifier of the party or the country that they represent, but the ideology of the party and the country varies over time and is a broad church. The ANC stands for many things, some of which AfriForum or members of society may find problematic, some of them which may not. But for a court's purposes, it could not look at a symbol, at a flag of a party or a country that is still in use and determine that it has one objective meaning that could render it hate speech for all purposes. So we submit, my Lord, that AfriForum's slippery slope argument is a straw man. Courts, including this court, will treat only hate speech symbols as symbols whose meaning is clear and unequivocal. They will astutely safeguard symbols whose meaning is positive or inoffensive, or even sometimes problematic, from being treated as hate speech under Section 10 in all circumstances. And there is no reason for the court to balk at making a finding in this case because of a spectre of unlikely results in other cases. My Lord, then the Johannesburg Pride therefore submits that the old flag falls clearly at the prohibited end of the spectrum, that its displays outside of the exceptions allowed in Section 12 of the Act constitute hate speech, that it also constitutes harassment, and that it constitutes hate speech and harassment both against black people and against members of the LGBTI community. Those are our submissions, my Lord.
Before you take a seat, you would be aware that AfriForum first responded and second amicus. All of them stayed. I'm not sure you'll be able to reply, so I pose the question now. Particularly AfriForum, their position is, yes, the old flag will be capable of those interpretations. That is they actually come expressly saying they support the cause of your clients. And of course, that comes against the applicants and their clients, who say declare this constitutes hate speech. If they are right, or could they be right in saying it has a different meaning for a section of the population, and therefore, for that reason, you shouldn't issue a declarator which would make it impossible for people to use it in private spaces. What do you say?
My Lord, we align ourselves with Mr. Chengov's submission that the declarator is targeting the public display of the flag, and that the private use and the purely private use, although it's hard to imagine when that would arise, but the purely private use of the flag is perhaps a fight for another day. But our submission in response to that is as follows. The AfriForum and FRK both accept that there may be offensive uses or offensive meanings attributed to the flag. We say that it goes further than that. It's not an offensive meaning, it's a hateful meaning. It's a hateful, harmful meaning, and the meaning is therefore unlawful under Section 10. But that we differ from them in that they say there is room for other alternatives to prevail. And there we say that cannot be so for two reasons. The first is that the question is not what a particular segment of the society understands the flag to mean, but what its objective interpretation is. And that objective interpretation is what Nelson Mandela Foundation in their heads has called the dominant meaning, or the meaning that is naturally ascribed to it by people who view it in public. And that meaning we submit is unequivocally as a symbol of the old state. And that can only be, my Lord, because it was the official symbol of the old state. That is the historical context in which it was adopted. And it has had no other opportunity to be used or to acquire a secondary meaning besides that, because its use is frozen at a moment in time. It is frozen at the point in time that we adopt the new flag. So, thank you, my Lord.
Support teasers.
Okay, I can help you.
So, my Lord, there seems to be hope I'm not too succinct for all this attention.
You for the second.
The second, no, my lord. I'm for the second and third respondent, the minister and the
Are
department.
you supposed to deal with Mr. Malay?
I am, and Mr.
What do
Malay.
you do with it?
My lord, I understand that you've allocated him for 2 weeks to sit on the bench.
I
So
didn't say he can't come and do his work.
that might be a private matter for a tea break, my lord.
Now, I do have your heads and your necklace.
Thank you, my lord. I am going to try very much not to repeat the submissions of the first and second applicants, but what I will be attending to in these submissions is the meaning of the flag and the department's interpretation of Section 10 and a potential way forward that the court might find of assistance. So our heads of argument have articulated the minister's view of the clear and dominant meaning of the old flag. And we have used that language on an objective standard, as has been stated in the submissions. And we say quite clearly that flags are conceived and adopted by countries to reflect a nation-state's political identity in the national and international sphere. For this reason, in order to arrive at an objective and dominant meaning, we have considered both the domestic interpretation, on which detailed submissions were made by the Foundation and the Human Rights Commission. We will not repeat those submissions, but we align ourselves with them. In our heads of argument, we made clear that the unity which, in particular, the FRK attributes to the old flag is unity amongst the white population in South Africa at 1927, to the exclusion of the black population. We submit that any present celebration of that unity is not only subversive to the unity of South Africa as a democratic nation, but does constitute hateful speech or hate speech against the black population. When we look at the international law position, we refer both to customary international law and thus circumstances where South Africa may not be a party to conventions, as well as international law to which South Africa is a signatory and a party. We submit that the value and applicability of international law is evident from Section 39.2 and Section 233 of the Constitution. We add to this Section 7.2, which requires the state, which has been interpreted, my apologies, to require that the state take reasonable steps to fulfill the rights in the Bill of Rights. And that arises from Glenister 2, my lord, at paragraph 105 and 189, on which both the minority and majority of the court agreed. In Glenister, the court made clear that to act in a manner that is contrary to international law would amount to the state acting unreasonably. And it is to that point that we address the remainder of our submissions. Against this context, we have considered in our heads of argument the status of the system of apartheid under international law. My lord, you will note that we have said that it is recognized as a crime against humanity. In our heads at paragraph 13, we draw to the court's attention the UN Convention on the Suppression of Apartheid, which is a 1973 convention which entered into force in 1976. And at paragraph 17 of our heads, we refer to the Rome Statute, which is a 2002 statute to which South Africa currently remains a signatory. Now, my lord, if I may turn to that's exactly where I was going to turn to.
You're still on the wrong stage.
I am still on the Rome Statute, but perhaps it'll assist if your lordship asks your question and I'll incorporate it. Did you have a question?
Well, you just said South Africa is signatory to the Rome Statute.
At present, South Africa has filed a notice of withdrawal from the statute in 2018, my lord.
Haven't you gone past that one?
Sorry?
Haven't you gone past that withdrawal?
No, we haven't, because that notice of withdrawal was withdrawn.
Yes.
Correct. So we're
We
still.
have gone past that because it's withdrawn. So we are in a state where it has not filed.
Normally, we're currently still, we're still under those obligations until we found,
Yes,
for
now that
present.
we are past the-
We are past and we're back in, correct.
The point I really wanted to kind of like brought to you for consideration lesson. South Africa and the Rome Statute. Beyond just ratifying the Rome Statute, even South Africa also passed a law which actually
We have done so,
implicated that.
correct. So we have
The Rome
to,
Statute is law in South Africa.
that is correct. Under the section 233 of the Constitution, we have done so.
But I wasn't quite sure of this is what I think.
Yes, no, we have.
Whether that is in relation to the criminal code only, or does it mean that until South Africa withdraw, South Africa is actually under obligation
That's correct.
to exercise the same jurisdiction that the ICC would
In the event,
exercise in relation to those crimes over which ICC would have jurisdiction if committed within the boundary of South Africa. I just thought you know what like that, in addition to everything else you have to say.
I will touch on that now, my lord. I wasn't planning to address that. But the situation is that, yes, South Africa is under an obligation, and it is and a matter, criminal complaint or criminal prosecution, would only go to the ICC where South Africa itself is either incapable or unwilling to conduct a prosecution in terms of international law under its own jurisdiction, domestically in its own courts. So at present, your lordship is absolutely correct. Until such time as not only the notice of withdrawal, but the period of withdrawal has completed, we remain obligated to conduct ourselves in accordance with our obligations under the Rome Statute. Is that...
Could I just put a more pointed question? At international law, let's say the former government constitution or past was a crime against humanity. Is it a crime against humanity in South Africa?
It is a crime against humanity.
In South Africa?
In South Africa through two different mechanisms, my lord. It's apartheid is a crime against humanity under international customary law. And I say that because your lordship will notice that in paragraph 14 of our heads, as well as paragraph 13.1 of our heads, we point to the fact that the General Assembly regularly and on an annual basis condemned the political system that was apartheid. So and we have given a definition of what customary international law is. So under that regime, South Africa has certain obligations against any crime of humanity, any crime against humanity. There are 8 crimes against humanity, and of which apartheid is one. However, South Africa, as is stated in our heads, did not, for obvious reasons, become a signatory to the Convention of the Suppression of Apartheid. And so we cannot be said to have a direct international law obligation, and we'd have to then rely on customary international law. However, what happened later on in 2002 is the Rome Statute then incorporated those crimes against humanity, and to that we are a signatory. So whether we remain a signatory to the Rome Statute, South Africa would still have customary international law obligations. And so on either leg, there are certain domestic obligations that South Africa would need to observe.
So theoretically, we could have a person held before South African courts and charge them with a crime of apartheid.
That is absolutely correct.
I don't know.
I think there'd be some difficulties, but the theoretical position remains. But in this case, we're dealing with a simple.
In this case, it's just
in this case, what we're saying about, and the reason why we reflected on international law, is again to get to that dominant meaning, an objective and dominant meaning. Your Lordship has heard about the domestic meaning using precedent and case law, and now our submission is on the dominant international meaning. Both the Convention and the statute we submit indicate a singular meaning attributable to apartheid as understood in the international sphere. It amounts to an infringement of human dignity, freedom of the person, and self-determination of black people, and it amounts to an institutionalized racism and subjugation and oppression of the black African majority by the white population. From that, my Lord, if I may direct you to Article paragraph 13.1 of our heads on page 7, we state that we record that apartheid was annually condemned by the United Nations from 1952 to 1990 as inimical to Articles 55 and 56 of the UN Charter. Your Lordship will note that Article 55 is quoted, and one of the principles of Article 55 is that of engaging in peaceful and friendly relations amongst nations based on respect for the principle of equal rights and self-determination of people, and the promotion of higher standards of living, full employment, conditions of economic and social progress and development, as well as the and this is sub C, universal respect for and observance of human rights and the fundamental freedoms for all, without distinctions to race, sex, language, and religion. And we would submit that that is precisely what apartheid undermined. If your Lordship refers to paragraph 14 of our heads, we quote Article 1.1 of the Convention Against Apartheid, which again refers to the practices of apartheid and similar policies and practices of racial segregation and discrimination. Article 2, my Lord, at paragraph 15 of our heads, says that the crime of apartheid shall include similar policies and practices of racial segregation and discrimination as practiced in Southern Africa, and shall apply to the following inhumane acts for the purposes of establishing and maintaining domination by one racial group of persons over any other racial group of persons, and systemically oppressing them. My Lord, I haven't quoted the examples in that paragraph because there are 14, and I did not think the court needed to be burdened with it. Now, if I may go to the Act, so we would submit in conclusion there, my Lord, that the international sphere reflects a dominant meaning that is entirely in accordance with the domestic meaning that has been already argued before your Lordship. In turning to the Act, we look at specifically at Section 10, and this is the basis on which the Minister and the Department have been joined as parties to the litigation. And we direct the Court to our heads of argument at page 13. At paragraph 30 to 31 of our heads of argument, we make clear that the proper interpretation of Section 10 is capable of a constitutional reading that avoids an internal absurdity when read in light of Section 2 and 3 of the Act. We have set out those submissions in some detail, but as Mr. Trengrove has already considered these aspects, I will not take your Lordship through them. But what we have said in our heads is that in the alternative at paragraph 38, that should this court find that the statutory interpretation of the first respondent, AfriForum, is to be preferred, the state respondents do propose a remedy. And we have set out a suggested remedy to an amendment of Section 10 of the Act. And the reason we have done so, my Lord, it is at paragraph 38, but the reason we have done so is explained in our founding affidavit. And that is the Department is considering and in the process of enacting the hate speech bill. And in this regard, the Department has been alive to the fact that the hate speech bill, the Equality Act, and the Equality Act should both be aligned to each other and as well fully encompass or give effect to Section 16 of the Constitution. In that regard, the department is of the view that Section 10 does require an amendment so that both the criminal aspect of hate speech in the Hate Speech Bill and the civil remedy under the Equality Act not only do not overlap, but are complementary to each other.
Everybody else says it's alternative. Are you saying is that also an alternative, or are you saying the section does require?
Our submission is that on the pleadings of this case, we believe that the section is capable of a constitutional interpretation. We believe that words can be equated to expression. That is clear. However, the department is also cognizant of what it is drafting in the Hate Speech Bill and what it is proposing under the Hate Speech Bill. And in that arena, it is considering an amendment to Section 10. And that is what we particularly wanted to draw to the court's attention.
Well, I sense that you might be going towards the end of your argument.
This is the end of my argument.
May I just say that I'm not quite sure which party might welcome your draft. It's actually not only refers to the bill, I'm not sure it produced its provisions. I take it because you're not getting into its content, that you would align yourself with the view that that's not law, that's not anything that I can have regard to.
Absolutely, my lord.
Please, you didn't that.
Yes.
Anything else?
No, my lord. Those are submissions.
Thank you. Mr. Oppenheimer, will you have been the next?
Yes, my lord. I would submit now is a good time for the lunch break.
But before we even talk about the lunch break, because lunch is only a meal, it's not a break. We are making very good progress. And I thought we would talk about this progress and what it implies. At the request of the parties, the court had provided for 2 days for the hearing of this matter. Having regard to the progress, of course, I think you will be arguing in answer and then comes a second answer. What sort of time do you think we're going to take? And should I still be holding tomorrow open for further argument, or are we moving to possibly finishing today?
My lord, I would submit it's unlikely that we will finish today, given that the two applicants will have to reply to what I say, and I intend to be a few hours after lunch.
I just wanted to check, because the time has been given. I just thought that this progress was being made in an attempt to save time, but otherwise, the time that the court has made available is available unless the parties have among themselves agreed otherwise. So shall I just presume that we are still in business tomorrow? Mr. Oppenheimer has indicated, his given notice is going to be quite long, and that there is the reply.
My lord, a few hours is really too long. No, my lord, an hour and 15 minutes. Mr. Trongov was 35 minutes. There is no reason to allow after forum a few hours to argue.
But I did not curtail anyone of your time. So I think if you'd like to engage each other about time, please do. If you had spoken to me before we start about the time slot we should make, I would have got you in. But I'm not quite sure I did not curtail anyone's time. I would curtail the time of others. That might be a nice thing to have over lunch instead of the meal.
I've made my point, my lord.
But you could still talk to her. We know you came here opposing each other.
Yes.
People may not know that you actually call each other brothers.
Not only brothers, learned brothers.
Leonard. So it looks like it will be an appropriate time for lunch. Any time restriction, or is it 2 o'clock, or I'm happy to come back earlier if you want.
Oh, my lord, we might as well come back at 2. They have no intention of expediting this. We might as well come back at 2.
All right.
Do you need... I'll pass this to Isabel. Do you want me to pass this to you? Which one?